Welcome to tonight's webinar, Understanding and Implementing Asset Protection Basic Principles. You know, these are asset protection and wealth creation strategies. And I get to do the introduction tonight because my good friend and partner, Don Pendleton, is on the call. And I am so excited to hear Don. Many of you have already had a chance to spend time with Don, and you know there's nobody better than Don to teach. I learned so much from Don. In fact, I think, Don, gosh, everything I've learned is from you, pretty much. I mean, since way back when.
We're in sad shape then, buddy.
I don't know about that, but thanks for being willing to do the webinar tonight, Don. I appreciate it very much. I know everybody else does too. Anyway, everybody, thank you for being here. We're excited to have Don on tonight. Let's go ahead and go through a few different announcements quickly before we get started. The first one is we have some events coming up here, and it's the 3-day Asset Protection Summit, and it's our live event. Don, if you want to advance that to the next screen, if you can. It's our live 3-day Asset Protection Summit, and I say live because it is a live event, and as you know, there's some question as to whether we can hold some of that in Anaheim, June 1st, 2nd, and 3rd, right there next to Disneyland. We're hoping if Disney opens, we can, but we're still looking at that. So we'll keep you posted if you are registered for Anaheim. But plan on Phoenix, July 27th through 29th, Orlando, September 14th through 16th. We're super excited about this event. If you have not been, of course, we strongly recommend, and honestly, and I do mean it truly, when we say there are hundreds of reviews that are extremely positive about this event, that is absolutely true. This event is our premier event, and there are attorneys, asset protection advisors, tax planners, financial advisors there for you one-on-one. It's always a great event, so when you can make that, we'd love to have you. Go ahead and register at protectwealth.com. You can visit the website there. We have an agenda available. You can take a look at in detail of what's covered. It really is a lot of information. And then as you see here, we have the Asset Protection Cruise coming up too. That's in December, so coming up pretty fast, faster than you think. Yes, we are still planning a cruise right now. So, and I say fast because it will usually come up fast, and I'm sure based upon how this year's going, it'll come up very fast. So December, start planning on that. Right now, we are planning on it. If you book now, it's still fully refundable. Again, December 6th through 13th. If anything changes, we'll let you know. It's a great course. If you haven't been on the cruise, it's it's one of the best. It's tax deductible, number one. And number two, you have the top instructors in the country. You get to spend one-on-one time with each of these great individuals and pick their brains over dinner on the beach, at the resorts. There's not a lot better. Anything to add to that, Don?
Nope, it's one heck of an event. If you get a chance to go, and by then I'll be ready to get out by the time December rolls around.
You bet. We'll all be ready to get out. I'm ready now. Let's get out. Thanks, Don. All right. Well, before we get started then, a quick disclaimer. Remember, this is not specific individual legal or tax advice. This is something that, of course, that's not individual for you, but you should seek competent legal advice from competent professionals. We're not giving you legal advice here, tax advice. So, but you guys know that we're an asset protection company. Sorry, I got background. My daughter's at the door. This is working from home. It's great. But thanks so much for being on. Oh yes, Don. You know what? If you don't mind, our good friend and partner Jay Mitten just passed away. Don, if you want to say a little bit about that.
It's been a rough weekend. Jay was the very first asset protection attorney in the nation to use limited partnerships. LLCs hadn't even been created when he started teaching, and he started separating assets from each other using these entities, and the clauses that he put in there were just absolutely incredible. In fact, now they've been you'll find him in almost every LLC limited partnership throughout the nation, even little boilerplate ones. But there's so many attorneys have followed his but he was the very first guy that was really winning lawsuits. He had some of the most influential, the wealthiest clients in the nation. And I had a chance to work with him as we wrote 4 books together and spend time as we'd outline chapters, as we would go over case studies, we'd strategize what about this and what about this. And it was the best training class, better than any law school, better than any. It was just incredible trainer to sit down with this master teacher as he's bowing out and I'm beginning my career. And I will miss him and his advice a lot. So anyway, tribute to him. He passed away Saturday afternoon, and best wishes and condolences to his family. So great friend and great mentor.
Well, thanks for that, Don. The thing about Jay, Don and I, Don knew him way more than I did, but I got to be around Jay, and right up until the end, Don, I mean, you spent some time with him even, not too long ago, and he was pretty sharp even then.
Oh, incredibly brilliant. Brilliant mind. He had the ability of looking at all the different legal tools available to him, picking out this and combining them together and things that baffled most attorneys, and because they'd never thought outside the box. Jay was an out of the box thinker. So yeah, that was it was a lot of fun working with him.
Don and I, we both owe a lot to Jay. He's a great guy, great example, massive inspiration to both of us. So, yeah, condolences to the family. Don, I get to introduce you, and what can I say about you, Don, before we get started? Honestly, truly, and I do sincerely mean it when I say you're one of the most masterful teachers I've ever heard, and it really is true. You can take a very complex subject, and you've done this with me a lot, poor guy. Yeah, a very complex subject that I still, frankly, I get wrong so often. You put me in the right place and tell me exactly how it is, but you do it with such grace and such ease. You can run circles around most advisors and attorneys that we know, and it really is true because you've done this again with Jay Mitten starting there. But you are an incredible teacher, and honestly, Don, thank you so much for being willing to do this tonight. We're excited to have you do this. Thank you.
Well, I like to be behind the scenes, but thank you very much. All right, so let's get into our topics tonight. Most attorneys and most books that I've read on estate planning, and I've read a lot, always cover asset protection entity by entity rather than asset by asset. But 21 years, 22 years now running a hotline, no one has ever called in. Of the tens of thousands of calls, nobody's ever asked and said, what can a corporation do for me? What can an LLC or a limited partnership do for me? They always ask specific questions about assets. How can I protect my home? How can I protect my retirement accounts? How can I protect my rental properties or my bank accounts or brokerage accounts? And so when Jay and I started writing books together, we wanted to attack it asset by asset, not entity by entity. Nobody cares what a trust can do. They just want to know, they want to avoid probate. They want to save money on taxes. And so we're going to talk about, and I'm not sure how far we're going to get tonight. We're attacking the 2 hardest ones first. The most difficult asset to protect is your personal residence. And beyond that, I think the second most complex is retirement accounts. And so, when it gets to rental properties, we use a series of LLCs. When it gets to bank accounts, we use limited partnerships. That's pretty standard. But what to do with personal residence, that can get complex. So we're going to hit the hardest ones up front. And if we can't get through all of those 8 asset classes, we will maybe do another webinar at another time, but let's hit the hardest ones. And because not only is it the hardest, it's the ones that we get the most questions about in customer service. So again, we're going to hit that head on. Let's start with protecting our personal residence. Again, there's no simple solution. It really is. The answer is it depends. But let me tell you what it depends upon. If you say how to I protect my home, here's what I'm worried about. I'm worried about losing my mortgage interest deduction. If I put my home into the wrong entity and if I've got a mortgage on it, I lose that. That's it. That is a big tax deduction for a lot of homeowners, and we never want to do that. I'm worried about losing the capital gain exclusion. Remember, if you go to sell your home, you've lived in it 2 out of the last 5 years, you're exempt from capital gains up to $250,000 if you're single, $500,000 if you're married. If let's say I sell my home and I've got a $400,000 gain, me and my wife, and I end up paying the capital gains taxes because I put that in the wrong legal entity. If it's not in your name or in a disregarded entity, you're going to lose that capital gain exclusion. So we're concerned about that. All mortgages after about 1980, mid 80s, are going to have a due on sale clause, which means if you transfer the asset into another entity, you're going to lose at least the bank has the right to call the loan due. They're currently not doing that. I don't know of any banks that are doing that because mortgage interest rates are so low and you'll just skip to another bank. They don't want that. They're not looking to do that. But if interest rates go up to 7, 8, 14, 15% again, you can bet the mortgage companies are going to start calling those loans due. So I'm concerned about that. I'm worried about state real estate transfer fees. A lot of you aren't familiar with that, but if you live in a state like Florida, they call it a stamp tax, or Washington or Pennsylvania. Those real estate transfer fees can be 1, 2, 2.5%, 3% of the assessed value of the property, and that can be really expensive to transfer a property in and out of legal entities. We want to be careful of that. If we transfer a property, let's say into an LLC or a family limited partnership or even a single member LLC, even a living trust, we're worried that the county recorder now goes, oh, property tax reassessment, and especially in states like California where you lose your Prop 13 rights because you transferred into a legal entity. We're very concerned about that for some states. We're also worried about tax filing requirements. Let's say I I transfer or convey my property into a multi-member LLC or a family limited partnership. Now every year I'm required to file a tax return on that, and I'd like to keep my taxes as simple as I can. I'm worried about losing the homestead protection. Some of you have very poor homestead protection that your state will allow, but some of you, that's a big deal. Those are the primary concerns. And then lastly, we don't want your insurance, your homeowner's insurance, to think that you're running a business out of your home and double or triple your homeowner's insurance. Those are the concerns. Now let's talk about some strategies. First of all, let's talk about some strategies that may or may not work. I'm not a big fan of using legal entities like limited partnerships, LLCs, corporations to own your home, although I've seen it done, and it could be done effectively. But the problem with using big business entities is, for the most part, you're not running a business. We're putting a family-owned asset or a personal asset into a business entity. Let's say I've got $1 million home, I transfer it into a family limited partnership. I think it's well protected, and then I get into a lawsuit. Somebody sues me personally. Is my home going to be protected? And I think the plaintiff's attorney might have the argument that, you know what, it's not protected by your state homestead. You're not paying rent. You're paying all the mortgage yourself. You're paying the repairs yourself. That it's not being paid for out of the limited partnership. You really, See, we're losing that whole business interest and the separation between business and personal assets. And I think that that's a valid legal argument that a plaintiff could use. I also worry a little bit about friendly liens. I like friendly liens. These are liens that you place on the property. Let's say I've got a Wyoming entity and I've got a little anonymity because I'm using a nominee officer or Nevada or Delaware. Um, and I put a lien using that into that Wyoming entity against my own property. For every contract to be enforceable, there needs to be equal and adequate consideration, which means a contract that would not be enforceable, let's say you hired me to come do your yard work and I got $1 million to clean up your yard, and I put 2 hours of work into it and the job was done. That would not be enforceable because it wouldn't be equal, adequate consideration. If I put a lien or my LLC in Nevada, Wyoming, puts a lien against my property for $1 million and there's no money exchanged, well, is that a line of credit? And does the legal entity have the ability to give me $1 million? All of those things. I love friendly liens when they're done right, but most people that I see use them don't do them right, and thus it causes a concern. Either they don't use the anonymity, there's no exchange for money, there's no consideration given for that contract. They announce to the world that they own the entity, and therefore it doesn't work well. The other thing that concerns me is land trust can be used very well. Sometimes in this case, we would call it a personal residence trust. But they and people will use this because of the anonymity that it avails you. But the mortgage is in your name. If there's a mortgage on the property, that's a matter of public record. The fact that you live there and drive up every day kind of messes up your anonymity. Even though, again, land trust is like a friendly lien. If it's done professionally, if it's done well, it can be an effective smokescreen. But none of these are really good A-plus asset protection. That doesn't mean that they can't be used. That doesn't mean it can't be effective. But if we get into trouble and there's a lawsuit prevailing against us, I'm not sure that any of those would hold up very well. They could avoid the and ward off lawsuits from happening, but once a judgment is rendered, I'm not sure that any of those three would work. So let's talk about what does work. And we're going to talk about these, I think, in order of maybe importance. Number one is homestead protection. A lot of you live in a state that offers really, really good homestead protection. We don't want to do anything with that. The states that offer 100% homestead protection would be states like Florida, South Dakota, Texas, Iowa, Kansas, Oklahoma, Arkansas. Now there'll be area limitations on that, and there are generally 11 or 12 exemptions to even homesteading. Florida is known as having the strongest homestead protection. That's why they seem to acquire all the Enron officials and the O.J. Simpsons of the world, that people can dump millions of dollars into their home and a judgment can't take that away. But I have over 300 cases here in my desk drawer of seizures in Florida homes. Most of them have involved drugs. So if you tick off the Federal Trade Commission or the IRS, they can come after you. Certainly divorce can come after you. Certainly there's things, if not paying child support, can come after you. If you stiff the contractor that's finishing your basement, he can come after you. Those would be common exemptions to even the best homestead protection. So even though homestead isn't it's probably the best protection for your home in some states, it's not absolute. And then for the rest of us that don't live in those states, the exclusionary amounts vary widely. Nevada, you can see on the screen, will protect the first $550,000 equity in your home. Massachusetts, if you don't apply for anything, it's $125,000, but if you fill out the application fee, last I checked, it was about $35. If you filled that out, then they gave you $500,000 of protection. Just automatic 125, but if you applied, some states you have to apply for it or you get nothing. Other states, it's just automatic. And so you have to check with your state. Arizona, California has some funny rules. 75 if you're single, 100 if you're married, 175 if you're elderly or disabled. Then Illinois, 15,000 is all they'll protect. Alabama stepped up 2 years ago. They went from $5,000 protection up to $15,000 protection. So sure, the people in Alabama are really happy about that. Pennsylvania will protect the first $300 equity in your home. Woo woo! And New Jersey, nothing. So you really have to check on your state to see what they will protect. And let's go back to this. And how do you do that? Generally, these are exclusionary amounts from bankruptcy. And let's say I lived in Montana, I could Google search and say what is the bankruptcy exemption in Montana, and it'll tell you the things that can't be taken away in Montana. And so, maybe they can't take away the first $3,000 in a vehicle. Maybe they can't take away, your personal assets up to $800. Maybe they can't take away your family Bible. In Texas, they can't take away your guns. In New York, they can't take away your family Bible. Every state has different rules, and every state will protect, except for Pennsylvania and New Jersey, something in your home. If they can't take it away in bankruptcy, federal bankruptcy, most likely they can't take it away in a lawsuit. Now, a judge, I've seen that argued, but I haven't seen that broken. So you can Google search your state and bankruptcy exemptions. I know we're not talking bankruptcy, we're talking lawsuits, but that's a pretty good standard to go by. Now, if you live in a state with poor homestead protection, and we don't want to rely on that, then we now look at states with tenancy by the entirety laws. Tenancy by the entirety is where husband and wife, and it's only husband and wife, and that would be husband and wife as defined by your state, and every state has different rules on that. I've listed the states that have tenancy by the entirety laws on your screen. That means that a husband and wife have an indivisible interest in that home. So if I'm transferring the home, I would on the title transfer it as, and I'll show you how to do that in a second, as tenants by the entireties. And that means if I get into a lawsuit, they can't take the home because my wife wasn't joined. If she gets sued, or there's a judgment just against her, they can't take the home. The problems with that is that if one of you pass away, then the other one inherits the home, and that you're subject to the lawsuit. Or if both of you get named in a lawsuit. So tenancy by the entirety is not an absolute. We would consider maybe about a C- grade asset protection. But if both parties are separate, and tenancy by the entireties does work, especially maybe in a state where you've got some homestead protection, let's say $50,000 to $100,000, and you combine that with tenancy by the entirety, that could work really well. The positives about tenancy by the entirety is that they can't attach the judge. They can't attach it unless they get a judgment on both. The concerns is the parties have to be married. The other concern is if both parties are sued, or if one spouse dies, Certainly it's not available in all states. So the process of claiming tenancy by the entirety is how you own the property. If on the deed of the property, you could file a quitclaim deed or warranty or some type of deed with your county recorder or your registrar of deeds. And you would title that, instead of, we used the name Bill D. Fortune and Iona Fortune, kind of a little pun, but you would change that to Bill D. Fortune and Iona Fortune as tenants by the entireties. It would say that right on the deed. And therefore, you've effectively transferred that into, and you've got access to tenancy by the entirety statutes, if you live in one of those states. If you don't, tenancy by the entireties doesn't do you any good. All right, another common way to do this is to rely on homestead for your state and then suck out as much credit through a HELOC or a home equity line of credit as you possibly can. In my case, my house is worth about $350,000. We still owe about 50 on it, so I've got 300,000. In the state of Utah, they will only protect $20,000, or I'm sorry, they adjusted that, $30,000, but it doubles if you're married. So I've got 40 or 50 owing on it. The state will protect 60. That leaves a lot of money laying out there, almost 300,000, for somebody to sue in a lawsuit. If I were to go down to the bank and get a home equity line of credit, let's say somebody was willing to give me a $200,000 line of credit, what that does is that effectively puts that bank or credit union in second position. As long as I've got the ability to sign a check for $200,000, the bank's going to keep a lien against my property. That means that anybody comes in after that would be subservient to that lien. It means that nobody wants to be in third position. The positives is that a home equity line of credit is easy. It's inexpensive. I'm only going to pay interest if I borrowed the money. It does avoid the due on sale clause because I didn't transfer the title. I kept it in my name. The mortgage company is still in first position. There's no state filing fees. There's no IRS regulations. There's no capital gains or mortgage interest concerns. But I do have a couple suggestions, and that is use the line of credit once in a while. Use it for a business purpose. Let's say I'm a real estate investor or a small business owner. I come in, I use the line of credit. There's a business purpose for it. And it's not just set up just to protect the home. That would cause a concern for a lot of people. Okay. Another avenue that people will use often is a revocable living trust. Now, we've told you all along for years and years and years that a revocable living trust doesn't provide any asset protection, and that is almost true. There can be some exceptions to that, and let me walk you through that. The positives of putting it into your trust is that it's easy. The positives is that it does avoid probate. We always want all your assets, whatever they are, or interests in other entities, corporations, limited partnerships, LLCs. We want everything to find its way eventually down into the trust. When I'm teaching, I often use the analogy of a big Tupperware bowl. Almost everybody has a big popcorn Tupperware bowl, but you never put it in the cabinet empty. You always put all the little Tupperware bowls inside of the big Tupperware bowl. This is like the trust. Yes, I have an interest in a corporation, but I want the stock of that corporation to find its way into the trust. Yes, I have an interest in an LLC, but I want my rights and interest to eventually come down to the trust. So the trust collects everything and then it will distribute it out. Well, the positives of this is that it's easy. It avoids the due on sale clause because the bank can't call the loan due. There's a 1982-83 Act of Congress called the Garn-St. Germain Act. You can transfer your home into a revocable living trust, and the mortgage company cannot stop you. They cannot invoke the due on sale clause because that's prohibited by Congress. There's no state filing fees on that transfer. There's no real estate fees in most states. Now you can mess that up, especially Pennsylvania is really tough. You kind of have to argue for that. In California, you have to let them know that this is my trust. Otherwise, they will reassess your property. But in California, you fill out what's called a preliminary change of ownership form. You fill that out correctly so that they know that you owned the house before you putting it into your trust. You own the trust, or at least you're the trustee, the trustor, the beneficiary. So as long as they know that there's no transfer, they won't cause your tax returns or your property to be reassessed. There's no capital gains loss, there's no mortgage interest loss, because the revocable living trust is a disregarded entity. So the very positives. The concerns is, again, the trust is not asset protection. It's a probate tool. However, on a marital trust, let's say I were to transfer the property not just into the family trust, but I were to transfer the property into my wife's section of the trust. So Don and Tam Pendleton, trustees of the Tam Pendleton Trust. So that what that does is that puts that in her side of the trust. And let's say it's for estate planning purposes. Let's say it was money that she inherited and we wanted to keep that, or we wanted that to go to her children, or whatever reasons we did. Now it's there it's not just for a year or two, but it's been there for 5, 10, 15 years. Now a lawsuit commences against me. Clearly, that was put in there for estate planning reasons. Could that provide like a D grade asset protection? And I will tell you that does work in some jurisdictions. I will tell you also it doesn't work in others. The length of time in the trust does matter because of the fact that your trust was revocable. It was amendable, it was changeable. I could move the assets in and out and in and out and in and out. It offers you no asset protection. If you have access to those assets, so would a judgment creditor have access. However, it's been in there for 15 years, named in my wife's trust. We've never moved it in. Clearly it's for estate planning reasons. Again, I would give this about a D to a D minus asset protection. However, it does offer some asset protection. So here's what most students do. We've gone through the 4 most common ways to protect the home. Most students will do a combination. Let's say you apply for homestead. Again, it's not automatic in a lot of states. And how would you tell? You'd go down to the county recorder, or sometimes it's the tax assessor, and you apply for homestead. So we apply for homestead in our state. Again, other states it's automatic. You have to check with your state county, or the county in your state, and find out how you apply for homestead. Sometimes it's a very easy application. Maybe they charge $15, $20 in your particular county, and then you convey your interest into the trust. So now I have probate protection, and I get whatever the state will allow me to have. Then I use a line of credit to suck out, again, as much equity as I can. Let's say I suck out 80% of between the first mortgage and what the state will protect and what I can get on a second mortgage. Is that adequate? And I would say most of the time, yes, it is. A judgment creditor isn't looking for your house. I'm sure it's lovely, but nobody really cares. They don't want to live there. What they want to do is they want to either place a lien against it so it keep you from selling it, or they want to force the sale if there's not enough equity. Nobody wants 80% of your home. They would fire sale the little bugger. They would sell it for 80% of the market. They'd pay the real estate commissions and whatever taxes, and it makes it a very unattractive asset. And then if we were to come along and now, if that doesn't work, let's say I've got a multi-million-dollar home and I live in a state with very poor asset protection, and maybe I've got bad credit. Could I then use a Wyoming or a Nevada single member LLC or something to protect the home? Yes, I would, but I would only use business entities if I were forced to. I would only use land trusts if it doesn't make, if I need to. I wouldn't use that as a first line of defense. These are the most common ways that people will protect their home, and beyond that, I would not do it yourself. I would probably get some legal advice. Come to our summit. We can teach advanced strategies. That would be a personal residence trust, a friendly lien. That would be using a business entity. But again, if you're going to do that, that's not something that I feel comfortable teaching people to do themselves. So that's sort of my wraps up, my discussion. If you want more information, we've just come out with the new version of the Asset Protection Handbook. A lot of you, maybe most of you on the call, already have a copy of that. As most of you remember, Chapter 1, Subchapter 1 was all on protecting your personal residence. We haven't really changed or updated that chapter because it didn't need to be updated. So on that, it's 16 pages. It's not a big chapter, but it's 16 pages, and we addressed all the issues head on. We didn't skirt around anything. We didn't play silly little games. How to protect the home. We knew that was probably the most important asset for a lot of you, so we put that right in the front of the chapter, in the front of the book. And then what we did was in the very back, we put in, here's your state homestead exemptions, and here are the state statutes. So even if the state changes it tomorrow and our book is out of date, and by the way, we update this book every 2 or 3 years, but if the book is out of date because the state changed their statute, you can always look it up. And so we've updated all of that in the new 2020 version of the Asset Protection Handbook. And then we've showed you 14 different case studies on how to protect the home. We've done as much as we can do to teach you how to protect your home, but if you've got that Asset Protection Handbook, you've got a marvelous, marvelous resource. We encourage you to read those 16 pages and look at the appendix in the back and use that resource. It's a great way to protect your home. We get most of the questions that we're getting in customer service from current clients, we tend to refer back to their textbook and have them read it right out of the book. So, all right, let's pause here. And before we go on to any other asset class, Kendall, let's take 5 minutes or so of questions on how to protect the home. Have there any been? I haven't been even watching the screen. So
yeah, Brian said my bank has said they would require a due on sale clause, right? So what are the next best options in Washington State?
Well, they will for an investment property, always.
Yes, yeah, investment property. That's correct.
That's right, but not for the personal residence. And so we're talking here how to protect our home, and the banks. If that's the case, then we would use maybe a land trust for that. But investment properties, we'll get to that when we'll talk about investment properties. They're very different on how we protect them than how we protect our personal residence. So
okay.
that'll come. Just hold on. Very, very different.
Scott then asked, that leads right into the next question, is a land trust or title holding trust good use for a primary residence?
Scott's in Florida. Yes, a personal residence trust can be used there, but I'm not sure why I would do that, because Florida has such great homestead laws. Just having it in your name is really sufficient in the state of Florida, or in the name of your revocable living trust. Up till about 7 or 8 years ago, if I transferred your home, if you transferred your home into the revocable living trust, it would disallow your homestead. Now they changed the law, and so you can have both asset protection of the homestead, and remember, Florida will also give you an income tax, or your property tax deduction, or they reduce your taxes if you've applied for homestead, your property taxes, and you get homestead protection. You can put it into the trust and it doesn't disallow that. So I don't see a reason why you do a personal residence trust or land trust for your personal residence in Florida. You could, but I don't see any reason.
Okay. And then Al asks about putting a lien on the property, maybe a HELOC. What about charging interest?
Could you do that out of your, so borrow the money?
Yeah, so if
and
you
then
are
charge yourself interest?
putting a HELOC yourself, you need to charge interest, correct, for borrowing the money?
Yeah, if you're borrowing the money for a business reason, so Al, if you're going to go buy another investment property and you borrow the money from your home, now it's for a business purpose. That sucks the equity out of your home, and it also gives you money to work on to buy the investment. You can also, that mortgage interest would then be tax deductible. Yeah, that would work, Al. Okay.
Good. Nice. All right.
Anything else on the homes?
Brian, I think last one. I created a family trust as a resident of California in 1993. In 1996, I moved to Tennessee. Does that affect my family trust?
Yes, it does. And it really needs to be restated. And in fact, Brian, anything after 2000, remember there's two particular rules for, or dates for trust. 2005 was the HIPAA provisions of the trust changed. And especially when it comes to powers of attorney that are attached to the trust, your trust probably ought to be restated. The issue that you have is you probably signed, as part of that trust, a medical power of attorney, let's say to your wife, who doesn't have the right to get in to find out if you're incapacitated. And so it will never spring into action. That springing power of attorney will never spring into action. So in 2005 was a critical date. 2012 was also a critical date. If you've got a trust that was dated before that, I would really consider restating those trusts, and make sure that they're current. Those two critical dates, 2005 and 12. If you've got a trust beyond that, I would, it's time to update it, Brian. Okay. So we ready to move on to how to protect? Yep. Okay, so let's do that. Retirement accounts are, a lot of people think that the federal law called ERISA will protect all retirement accounts, and the O.J. Simpson case really brought that to light. If you remember that, they couldn't touch his Florida home because it was protected by asset or by homestead, and they couldn't touch his NFL pension plan. He was reportedly taking $25,000 a month out of his NFL pension plan, and the best attorneys in the nation could not attach it. Remember, the Goldman family had a multi-million-dollar lawsuit against. They won the lawsuit against him, but they couldn't satisfy the judgment because, at least on those things, any other assets that he might have had in California or anywhere else, they could have been gone, but they couldn't touch his NFL pension plan because it was protected by ERISA. However, a lot of plans are not protected by ERISA, and this is a chart that you really kind of need to pay attention to. Now, this is general, and Not always. So the qualified plans are those that would be covered by ERISA. Sometimes that term qualified is used for a lot of reasons, but in the legal community, qualified really doesn't mean that it's in an IRA. It really means that it's protected by ERISA. And so that would, and then the qualifying rule is not what type of plan it is, as much as it is, did your employer contribute or did you contribute? If you contributed, then it will be, it's a non-qualified plan and it will be protected somewhat by state law. If, however, it was an employer-sponsored plan, a 401k, deferred comp plans, some HSA plans, some of them, if you're the sole contributor, it won't be protected. SEP IRAs are generally, well, they're sponsored by the employer. Welfare plans, those type, again, the qualifying rule is not what type of plan, is was it an employer sponsored plan, and if so, we'll get to 401 rollovers in a second. If it was created by the employer initially, that's a qualified plan. All right, so, and then even with it being a qualified plan, it still needs to meet federal guidelines. Whoever's the administrator or the custodian has to meet very, very stringent guidelines. And most of them do, but every once in a while you hear of somebody, an administrator that didn't meet the qualifications, and therefore everybody that all the accounts that they're managing lose that asset protection. That is a big deal. Because when you lose your asset protection, a lawsuit comes against you because your administrator failed to follow plans or the federal guidelines. That's a big deal. So how do you check with that? Watch the news on your administrator, and then if you call them and ask them, they're going to say that they qualify, but watch the news. If your plan is being held by, I don't know, whatever, Charles Schwab, or as long as they're meeting federal guidelines, your plan is protected. Then there are some things that can even break into a federal ERISA plan. That would be federal fines and penalties. That would, you remember federal law can trump federal law. Support obligations. So if you're not paying your child support, your divorce settlements, and let me talk about that for a second. Over the years, I've had hundreds and hundreds of calls from husbands who go, my wife never contributed to this plan. This was my plan. I was the employee. She stayed home with the kids. Therefore, she shouldn't get half of the, and the courts don't see it that way. They see your marriage in almost all cases as a partnership. And if you get divorced, most commonly, she's going, the spouse, whoever that is, will get half of that settlement, or at least maybe they'll substitute. She'll get the house and you'll get the 401k, but assets that are acquired during the marriage are generally tried to split 50-50, even though she never contributed to the. It doesn't matter. There were assets that are acquired during the marriage. So divorce settlements will certainly break into even an ERISA protected plan. Federal bankruptcy can, but there are some rules on that. Is let's say I contribute a whole bunch of money to my federal plan. If it hasn't been in there for at least 2 years, bankruptcy can take that away. If it's been in there for a long time, even bankruptcy, federal bankruptcy, it usually doesn't touch your federal ERISA protected plan. IRS debts can, although the IRS generally leaves ERISA plans alone. But again, if you contributed a lot of money within the last couple of years, chances are the IRS will come take it away. So those are the known exemptions. That says on your screen it says known exemptions, not no. Anyway, whatever. Okay. Now let's talk about non-qualified plans. And first of all, we need to know what your state will protect. Every state has, just like homestead protection, every state has different laws on protecting IRAs. And I'm going to say IRAs, but I'm saying that as kind of a blanket. So any non-qualified plan, I'm just going to lump together as IRAs here. For instance, there are 4 states that will protect traditional plans, but not Roth IRA plans. Those are Georgia, Mississippi, Montana, West Virginia. I'm not sure what the state legislatures are thinking, why they will protect a traditional but not a Roth, but those are the laws in your state. Some states like California leave it to the discretion of the judge. If you've got $5 million in other assets and the judge goes, yeah, that's really more than you need, you really, there's a little sob story, and and so you really owe this plaintiff some money, they will rip into your IRAs. Most states will protect up to about $1 million, but then there are some states that will only protect, let's say, 60,000 or 100,000 or 120,000. Every state has different limits. What we did when we updated the Asset Protection Handbook is we not only rewrote the chapter on protecting retirement plans, but we also added a huge appendix at the back saying here are the state exemptions. I don't know anyone in the nation that's really teaching this or has done the research on this like we have, but that was a tremendous addition to our new Asset Protection Handbook, was that appendix at the back and the new chapter on protecting retirement accounts. Other ways to protect non-qualified plans. If you've got a retirement plan that's non-qualified, like an IRA, you're now exempt from federal bankruptcy up to $1.3 million. That's adjusted for inflation every year. So at least you're protected that much from federal bankruptcy. You might consider, if I've got a lawsuit rolling down the pike, I might want to consider rolling the funds from an IRA into, let's say, a solo 401k. If I've got a corporation set up and it's contributing to my solo 401k, rolling funds from a non-qualified plan to a qualified plan could give me federal protection. Number 4 is, let's say I'm leaving a company. I've either retired or I've left. I had a 401k with them. And now I could roll this over to a self-directed IRA. Most of you, as long as you understand that if you do that, you're going to lose the federal protection that it avails. Now I'm dealing, because it went from a pension plan or it went from a 401k plan. Now if I roll it to an IRA, even though I now have options to self-direct, I also lose the federal protection of ERISA. So sometimes to keep those plans or only roll a portion of it that I plan to invest in real estate or whatever I'm going to do, but I would consider number 4 to be a pretty good option. Keep that ERISA protection as long as possible. Number 5, let's say I've let's say I've quit my job or I've been retired. I've got $1 million pension plan, and it was protected by federal ERISA law. Now I roll it to a state plan, as long as I'm rolling it to an IRA. As long as I don't contribute more money and I've left that intact, I still have federal ERISA protection, even though it's an IRA. But if I combine accounts, I'm using a qualified plan and non-qualified plan, then I lose the ERISA protection. 5 is a big deal, and that was a surprise to me as I was researching this. But again, I can, even in an IRA, I can have federal ERISA protection for my IRA as long as all of the money that was contributed to it came from a federal ERISA plan. I know that's a strange thing, but that's how it works. Number 6 is if I've got a lot of money and I'm worried that the state I live in doesn't protect it, one of the things I may consider at that point is change the nature of the assets. I used to have a little dog. Well, it was not a little dog. It was a golden retriever, and he ate everything. He would chew all the kids' toys. He'd chew the garden hoses. He'd all the furniture in the backyard. He'd chew the chain link fence. Anything we put back there, all the balls or football or soccer ball or anything, he'd chew it up. And so we learned it to use bitter herb spray. We'd spray it on everything we didn't want him to eat. And as a result, he kind of stayed away from that. So what we're doing here is we're changing the nature of the assets. Nobody wants an annuity. In a lawsuit, it's a very unattractive asset because it's going to pay out over time. Plaintiffs' attorneys are looking for money that they can get right now and not have to cash in for pennies on the dollar. And so sometimes changing the nature, let's say a real estate investment trust, isn't as liquid as a piece of real estate. Looking at assets that are unattractive sometimes can save that account. And then I put down number 7, and that is family limited partnerships. I would use that as a last result. If I lived in a state and that had very poor asset protection and I was at a high risk, I may consider cashing out my IRA and putting it into something that is safe. I understand there's taxes and penalties. I get that. But if I could protect 70% of my IRA, that might be better than losing the whole thing. So those are my suggestions for protecting non-qualified plans. Not all of them are attractive. I understand that. But again, lawsuits are not fun, and if somebody's coming after me, I'm going to put up every barrier that I possibly put to protecting my estate. Now, what we've talked about up till now is protecting your retirement account from outside lawsuits. But I'll tell you that just as big as and as important as protecting your estate from outside lawsuits is protecting your retirement account from what you do inside. And I'm not saying bad investments. I'm saying things that can cause lawsuits inside. So the very first thing that I would consider doing is separating unsafe from safe assets. Unsafe things are lawsuit or things that can cause lawsuits. Real estate can cause lawsuits. Stocks and bonds, mutual funds, gold and silver, precious metals can't. And so I may consider having more than one IRA. Just like you would consider putting each property or groups of properties in a separate LLC, I might consider putting unsafe assets in separate LLCs to divide those up based on your tolerance for risk. Let's say I've got a $2 million estate and I've got some rental properties, some of them in my IRAs. I might separate those, not a separate IRA by each property, but I might group them into small. Let's say my tolerance for risk, I don't want to lose anything, but if I did, if I lost 15%, I could probably bounce back. Okay, so I keep good insurance. I keep a good management company. I do my best. But if I had 15%, I'm dividing, instead of having all my eggs in one basket, I am dividing this into baskets. And maybe I put 2 or 3 little rental properties or rental properties with very little equity, and I can stick those together. As far as your safe assets, that could be billions of dollars. So on the screen, IRA number 1 could have billions of dollars because there's no inherent risk. But once we have risk in that, we might consider separating those assets from each other by having a different IRA. just like you would have a different LLC. Now, another strategy is to use single member LLCs that are solely owned by the IRA. That could separate the properties from each other. Now, if I lived in a state like California, where it's $800 a year to have each LLC, I don't know that I would do that. I'd have more IRAs. If I lived in a state where it's $10 a year to have an IRA, I'm sorry, an LLC, that's the filing fee. I think Utah, it's $20 to have an LLC. For the filing fee, I might use the strategies shown on the bottom of your screen. So it really depends. What's your custodian paying you for filing fees or custodial fees? The only thing that I dislike about the second strategy, the one on the bottom of your screen, is if I fail to pay the filing fees, whatever that is, whether it's $10 or $800 or whatever it is. If I fail to pay that and I'm not current on my LLC filing fees, I've lost the asset protection. And so be careful of that. But number one, I want you to protect the safe from the unsafe assets. Number two, what I want you to do is avoid prohibited assets. Things like art, stamps, wine, baseball cards, collectibles, jewelry, rugs. Life insurance policies on yourself or your family members would be prohibited. So we can't do that. Now, that doesn't mean you can't buy in life insurance contracts on other people, but just not on your family members. That would be prohibited. Stock in a subchapter S corporation, that would be prohibited. And so what you're doing is, if you're investing in those things, you're blowing up your IRA from the inside, because you're not really self-dealing, but you're investing in assets that are prohibited. A third way that you can blow up your IRA is by trading or dealing with disqualified persons. Disqualified people would be like yourself, your spouse, ascendants, parents, grandparents, people up your generational line or people down your generational line, children and their spouses, grandchildren, anybody down, great grandchildren. That would be, so any transactions that are done with them or corporations that they own, LLCs, trusts where we have a disqualified person. So could me and my corporation, could I loan money from my IRA to my corporation? No, that would be my corporation is a disqualified person. And so any transactions that are happening between you and those can blow up your IRA. So we don't want to do that. And now what happens if you do is you lose whatever state protection you had before, whether it was good or bad. If you're not playing by the game here, you lose the protection. And plaintiffs' attorneys have become very, very savvy to this. I'll talk about that in a minute when we talk about checkbook IRAs. A fourth way you can blow up your IRA is by engaging in self-dealing or prohibited transactions. Paying a management fee or a consulting fee to a disqualified person, selling or leasing or exchanging assets to disqualified people. Things like borrowing or lending money from disqualified people, living in real estate. I can't live in my home if it's owned by my IRA. That would be, or my kids can't do that. It's okay for your IRA to, or your solo 401k, it's okay for them to own investment properties, but you can't lease that or rent that to disqualified people. That would blow up your IRA. Compensating a disqualified person. I always tease that my brother-in-law, who I hope is not listening tonight, is the poster child for how to do it wrong, because he pays his kids to mow the lawn, and in his investment properties owned by the IRAs, and that would be disqualified. Providing sweat equity. So it's okay to have investment properties, but you can't fix the fence. You can't paint the walls that need to be painted. You can't work on the property, swing a hammer. That would be prohibited. Those things can blow up your IRA. And the last thing, I'm not a big fan of checkbook IRAs. I put the fireworks there for a reason, because I've seen so many people, although a checkbook IRA allows you tremendous flexibility, you also lose the oversight of having a custodian look over your shoulder and make sure that you do it right. And with that, almost every checkbook IRA that I see has disqualified transactions in it. I was speaking with Dennis Blitz here, who runs the IRA Club, a few months ago, and he was telling me about a guy who was fixing his houses, and he wasn't doing the work, but he was hiring contractors. But every couple days, he'd go down to Home Depot, buy stuff for the IRA. And it may have been a solo 401k or a QRP or whatever it was. But as part of that, he'd get to the checkbook or he'd get to the check stand at Home Depot, and he loved diamond almonds. So he'd buy a little bottle of diamond almonds, a little can, and that showed up on the receipt. Well, let's suppose, and this is my biggest concern. It's not the IRA, and the IRS would disqualify that, but they wouldn't blow up the whole IRA. They'd make him pay the taxes and penalties on all the little cans of diamond almonds that he had bought. But a plaintiff's attorney is not going to be that forgiving. And what we're seeing time and time again is if a plaintiff, they're in the middle of a lawsuit against you, they find out that you have a checkbook IRA, almost always they're going to subpoena all of the records of that checkbook IRA. If they find that you've done anything wrong, anything. Okay, I got muted there for a second. If they find any inappropriate actions, they're going to appeal to the court to have your IRA protection set aside. That's a big concern for me, is that you don't have somebody looking over your shoulder. So those are my concerns with checkbook IRAs. Here's how to keep your retirement plan safe. Again, when we rewrote this handbook, this new 2020 version, and it just came out about 3 weeks ago, what we did was we expanded the section from 2 pages to, I think, 16 pages. And we added this tremendous, I think it's about a 9-page appendix at the back, where we go through state by state and say, here's what your state will protect in your IRAs. And it shows the 4 states that don't protect Roth IRAs. We added that wonderful appendix, and then there's at least 14 case studies where we're showing you how to protect the IRAs and the retirement accounts, whatever they are. So that was a big deal. Let's take a few minutes, Kendall, and wow, we may not get to protecting everything else, but let's
Time flies when you're having fun, Don. That's great.
Yeah, I guess so. Let's at least answer some questions on protecting retirement accounts.
Okay, and I think you covered this pretty well. Our solo 401k plans protected by ERISA.
And the answer is it depends. If it was an employee-sponsored plan to begin with, and I didn't contribute any more money, then yes, it is. If I'm the only one that's contributed and my employer didn't, then it would not be a qualified plan.
All right, and do annuities have asset protection? And if so, do different states have an effect on the asset protection?
Well, IRAs can own, and qualified plans, non-qualified, they can own annuities. So there's no asset protection. It's just something that nobody wants. It's like, my dog eating the hose that has bitter herb spray. Nobody wants an annuity that's going to pay out over 20 years. Okay.
It's a contractual relationship that goes for that person beneficiary only. It's pretty tough to break that. Yeah.
Correct.
All right, so you answered this a little bit. What's the best time frame to roll over if in a lawsuit? So fraudulent conveyance. Is there a time frame? That's a tricky one.
You know what? It really is, and that one, the most complex area of law is how to deal with a lawsuit once it's already started. And I really don't know that one. But I wouldn't roll that over unless you had a darn good reason or had some good legal advice on that rollover. Now, I will tell you though that fraudulent conveyance is based on the intent of the reason why you're doing it. Let's say I've left at I don't know, I'm looking for better protection and my state offers $1 million. I don't know. I would, if you're doing it for sound investment, I've got a better investment if I will roll it over to this. If you're not doing it for the sole purpose of keeping that guy's grubby little hands off my assets, again, fraudulent conveyance is based on intent. Was I doing this with estate planning? Was it an investment motive? What was the motive for me making the transfer? That's what fraudulent conveyance will be based on. But again, I would be really careful in the middle of a lawsuit.
Okay, and Akbar that has a good question here. It's about a 401k. Would the divorcing spouse get half the full account value and appreciation? Who pays penalties? That may be a more phone call directly with you, Don, but is there any comments on how divorce would affect a qualified plan?
Well, there might not be any penalties or interest. They would just set up two accounts and split the account and keep it, and so that doesn't have to be. And it doesn't mean that a divorcing spouse gets half the half the account. Again, if you took the business assets and she took the retirement accounts, or you took the equity in the home, and the goal of the divorce judge is to split assets equally, and then they consider in what you brought into the marriage. Was this inherited? But again, the goal is to split the assets combined 50-50, but that might mean you get this and she gets that, or whatever, Akbar. Without knowing more details, I don't know how to answer the question.
Okay. All right. So Brian asked, I have a rollover IRA, both standard and Roth from previous work plans and other self-directed, and a company 401k safe harbor plan with ERISA. It's my company plan, but I've been told I cannot roll my IRAs into this plan. Are there any options for those?
You really need a good plan administrator who's, and look at your specific plans. I can't give with 150 plus people on the call. I don't know how to answer that because I don't know the specifics of your plan. Generally, yes, you could. Specifically, I don't know.
Okay. All right, let's take one more on this one and move to the next one. I do a lot of investing with my Roth IRA with my brother. Everything I've researched doesn't mention brothers as disqualified.
That is correct. Brothers are not ascendants or descendants. And so your brother and his wife would be, they're not a disqualified person. Siblings are not. Cousins are not. But I would be a little careful just to make, would you be under more scrutiny? I think you would, but it's not a disqualified person. Correct.
Great. Okay. We have a few more popping up, Don. What do you think, time-wise?
Well, let's address just a couple things here real quick. Whoops, I didn't mean to do that, because our next asset, we were going to talk about small businesses. Beyond that, we were going to talk about, I don't know what we were going to talk about protecting bank accounts. We're going to, and maybe Kendall, maybe we just need to redo this again in 3 weeks, 2-3 weeks, and where we talk about how to protect rental properties, how to protect small businesses, how to protect personal assets, vehicles, motorhomes, things like that, how to protect intellectual property, how to protect bank accounts, brokerage accounts. Maybe we have a section 2 rather than trying to stuff all this in tonight.
Well, the problem
I'm
is
okay with that.
nobody's, they don't have time for this. They're not, it's not like they're quarantined at home.
So let me slip through this real quick and let me get to a lot of you that have so many questions. Again, if you've got an asset protection kit, I encourage you to go back and use that. There's some really good DVDs inside of that. You've got the Asset Protection Handbook that's in that. 2 weeks ago, Bob Bloom did a great webinar selling the Asset Protection Kit. I think he reduced that to $997. We've never sold it for that. It's always been a $2,000 or $3,000 product. Kendall, if somebody's really interested in that, is that okay if we extend that?
Yeah. So
that offer?
Yeah, I can make that available. So I'll put that on the next couple days. Protectwealth.com/home study. I made sure to make that available since I knew you'd be talking about the handbook tonight. So that includes the new version 2020, which I did. Don did so much work on this. I saw a lot of the work go into this. A lot of stuff has been updated. So if you're overdue, there's been a lot of changes.
So let's finish up with questions, and then we'll talk about protecting intellectual property, bank accounts, personal assets on another webinar. So let's take what we can here. Questions. I'd rather not walk away with and leave questions unanswered.
All right, let's do it. Okay. The Iva is asking, the employer is LLC owned by husband and wife and contributes to the solo 401k. Does it mean that it is still protected under ERISA? Kind of answered that one.
Okay, so the husband and wife are part of the corporation.
The employer is LLC owned and husband and wife contribute to the solo 401k. So it must be yes.
Yeah, so the corporation is, so Kendall and I own a company and we both have SEP IRAs, but we don't contribute, the company does. Every year the company will provide, so our Protect Wealth Academy will fund, depending on how well we did that year, up to 25% of our salaries and contribute that to our individual SEP accounts. It was employer contributed, meaning the company did it. It wasn't me. I didn't take the money out and contribute like I would an IRA. Therefore, it's protected by ERISA.
Cool. Okay. Kind of cool. All right. If my father's solo 401k invests in a privately held company that is a client of my company, would that be a disqualified transaction?
Yeah, I think that it would, because he's investing. Yeah, you know what? I don't know. That's kind of a gray area. Would I attempt to do it? Because it's benefiting. It's not directly benefiting your company.
Yeah, and
it's a client of your company.
Yeah, it has no ownership or equity interest in the company, only a business relationship, and would only receive compensation for the investment and would derive no other benefit. It's tricky.
I don't see that as a disqualified person. You can have business associates all day long. That doesn't mean they're a disqualified person. I would say, without looking at all the details, I would say that would be allowable. Sure. Okay.
Okay, Barbara, so if you have a small corporation, would this ever be put in a revocable living trust?
The stock would. Yeah, what we would do is Barbara, you would go back, if the stock certificates for your corporation were titled in your name, let's say you had 500 shares of this little corporation, we would go back and retitle those in the name of the trust. And so, Barbara, it would instead of saying Barbara on your stock certificate, it would say Barbara, trustee of the bank's revocable living trust. And it would say that right on the stock certificate. If you're having problems finding that, you'll find a stock certificate, a blank stock certificate, as a template in Word. In Microsoft Word, it's right there on your computer. You just didn't know that it was there, but there's a blank stock certificate. You can go back and retitle that stock certificate, reissue that. if your corporation is required to have a stock ledger on the records of the with the state, you might have to reissue that stock ledger or update the stock ledger with the state. But it's a very simple thing. Then if you pass away, those stock certificates avoid probate. Yeah, that's a really good question. Thank you.
Great question. Okay. All right. Any new updated states that ignore the single member LLC charging order? That's more asset protection related, but yeah.
Most states, unless there's a lot of states that have been silent on the issue, but there's only 5 states who have said we will give charging order protection to a single member LLC. That would be Wyoming. They were the very first. Nevada followed, Delaware followed, South Dakota followed, and Alaska followed. So those 5 states will offer charging order protection for a single member LLC. The rest of them, some of them have come out and very clearly Florida said we will not give charging order protection for single member LLCs. If they've been mute on the point, or if their cases haven't supported charging order protection, I would stay away from them. So what we'll do is we'll still use single member LLCs, but then nest them or own them in a state that has stronger asset protection.
And you'll probably cover that more when we go over rental properties, because a lot of people misunderstand single member versus multi-member LLCs. If there's one partner or member of the LLC, that's a single member. Disregarded.
But so let's do that next time we teach. Let's talk about how to protect rental properties and maybe intellectual property or something else. Okay. Yeah.
Okay. Now, Andrej, does salary deferral count? That's referring back to the retirement plans.
Okay, so deferred compensation plans can be protected, and you go back to that chart that I showed. Let me find where that was. There we go. So deferred comp plans, if the company contributed this, then yes, that would be protected by ERISA. Okay.
Very cool. All right. Okay, Todd, I have an LLC holding rental properties held by my IRA custodian, like IRA Club, iPlan Group.
Sure.
Should I make the beneficiary of the IRA my trust? I would like my trust to keep generating the rental income for my heirs.
The IRA already is a trust. We don't call it a trust, but it is. It has beneficiaries. It falls under trust rules. And the rule is a trust can't own a trust. Now, the trust, your IRA could be have a beneficiary. Generally, we don't want to do that. We want it to go to a specific person. But have I seen IRAs where I listed my wife as the beneficiary and my trust, my revocable living trust, as the contingent beneficiary. Yeah, that's a very common thing to do. And therefore, what will happen is that IRA is now owned, when both spouses die, the IRA is now owned by the revocable living trust, and the kids now fall under inherited IRA rules, which can be a little complex, but yes, can you do that? Yes. Is it ideal? It's probably better to go to a specific person, or maybe it's split between 3 people, and not go through the trust. But can it be done? Yes, it can, certainly.
Okay. All right, great question. Okay, so can we buy the handbook? Michael, give us a call directly. It comes in the asset protection kit. That was protectwealth.com/ what was that one, Don?
Oh, yeah.
It was
let's go back to that.
Home study. There we go. So protectwealth.com/home study. If you're looking for more detail, just give us a call directly. Okay, Andrej asking, I'm talking about salary deferral as employee contribution as part of the 401k plan that has a salary deferral employee contribution component and profit sharing as employer contribution. Okay.
So that's a deferred comp plan.
Yeah. It
Yeah,
really is.
I think so.
Yeah, so
Yep.
it should be covered.
Yep.
Good.
And again, there's exceptions to every rule, and I'm giving you some general guidelines. And the general guideline is if it was an employer-sponsored plan, it will be protected by ERISA. There's exceptions to every rule, but that's the prevailing thought process is that if you contributed to it just yourself, you're the sole contributor to your plan, it will not be protected by ERISA.
There you go. And I love how, like you said, Dennis puts it, unless you're doing anything else but picking up a pencil and writing down for your plan, you got to be really careful. You can't go and paint the property. Yep, pick up the pencil. That's all you can do.
That's really good. I hadn't heard that, but that's good analogy. Thank you.
Pick up the pencil. Don, it looks like we answered most of the questions. That's great. Thank you very much.
Well, we've had fun tonight. Thank you for being here, and as we appreciate your loyalty over the years. We will hit the rest of the assets. We'll hit how to protect rental properties. We'll hit how to protect small businesses. We'll hit how to protect personal assets, bank accounts, brokerage accounts. We'll hit intellectual property. So watch our emails. We'll hit those. But I felt it was more important that we cover each subject thoroughly rather than breeze over it. And I hate when there's questions outstanding and we just didn't have time to. So I apologize. We were not trying to be misleading in our advertising on this, but we will try to be much more specific in the future. Anyway, any other closing comments, Kendall?
Well, I will say probably what I'll do is in the next week or two, we'll send out another webinar reminder for the upcoming dates. Don, you'll cover the rest of the entities and assets. Really, really good. I've looked over the protecting rental properties. So stay tuned for that. I'll send you an email. Make sure you register for that. Make sure you go all the way through the registration process, and we'll get you the link for the upcoming webinars. And also, if you want to copy the recording, you also need to go through the registration process. Perfect. Okay. There you go.
Kendall, thanks for all your support in the background. And most of all, thank you for all of you being on the call tonight. On the screen is 3, 4, 5, 6, 7, 8. We have a lot more to cover in the future. So thank you for being with us. Have a great night.
Don, you're awesome. Thank you so much, everyone. Have a great night. Stay safe.